Welcome everyone to today's session, which is of the Know Your Right of free webinars that Carers New South Wales has been delivering with our partners as part of the Carer Rights and Complaints project that we've been delivering for the past few years. And we'll talk a little bit more about that project later, but I first wanted to say welcome and just alert you to the fact that there are other webinars in this series that you may be interested in. We want to first acknowledge the traditional custodians of the land that we're meeting on today. It's a little bit different to what it would usually be, since many of us are working from home that might be joining, including myself. So I'm presenting today from the Wallamedigal lands in Epping. And I want to extend my respects to elders past, present and emerging of other lands as well that are represented today across New South Wales. And we particularly want to acknowledge the importance of caring in Aboriginal and Torres Strait Islander communities and extend our respects to any Aboriginal carers joining us today. Most of you will be aware of Carers New South Wales having heard about this webinar, but in case you're not, Carers New South Wales is the peak non-government organisation for family and friend carers in New South Wales. And just a quick note that when we talk about carers today, we're talking about carers as they are defined in the New South Wales Carers Recognition Act, which relates to family members and friends that are providing care to someone with any of the conditions listed. So it may be a disability, mental illness, frail age. And so we are not talking about paid care workers or the other groups listed, just family and friend carers, or informal carers as they're sometimes known. So the session today is going to be, I will do a brief introduction, and then for most of the session we'll be hearing from Donna from the Welfare Rights Centre on many aspects of Centrelink services that apply to carers. I think it's going to be a great presentation. I look forward to learning a lot myself. So we'll also talk at the end about future webinars in this series as well. And as the session outline says, our focus today is on looking at Centrelink payments, so income support payments delivered under Services Australia. And it's worth noting as well that sometimes people would define carers narrowly as people that are receiving care payment from Centrelink, but the way we define carers includes anyone that meets the description that I referred to earlier. So we're not just talking about carers on care payment, we're talking a bit more broadly about carers and income support today. Some of the other webinars we've had have focused a little bit more on the person being cared for's interaction with services. Today, we're looking a little bit at that, but we're also looking at the many aspects of Centrelink that do relate to carers directly. And as with the rest of this series, this webinar speaks directly to a fact sheet that was developed on the same topic. So again, if you have any questions, the key points will be in that fact sheet, and we will send that fact sheet link to you later in the webinar. Before we introduce Donna, I guess just the next slide, I think, just overviews the topics of the other webinars that we've had. So some of you may have joined us for prior topics. All of the topics that are grayed out there are ones we've done in previous months this year. They are all available as recordings on the Carers New South Wales YouTube channel, which again, we can send you the details on after this session. As you can see, we're up to session 6 there today on Centrelink. We've got 2 remaining in August and September, which you're very welcome to join. And the purpose of this series, it's based on a series of fact sheets, and the aim is to help carers understand what their rights are in different service settings and different situations, and to encourage them to use the supports and the complaints pathways that are available to improve situations which may be frustrating or may prevent them from accessing support. And so that's really our purpose today, and we're going to be hearing from Donna about the options that are available when you're running into walls around income support payment through Centrelink. So if we can go to the next slide, I will introduce Donna without further ado. So welcome, Donna. Donna Flood is a solicitor and community liaison officer with the Welfare Rights Centre in New South Wales, and we're very pleased to have her here today. She's a wealth of knowledge on all things Centrelink, and she's going to talk to us about issues relating to carers and carer rights and complaints in Centrelink. And please, if you have questions for Donna throughout, feel free to post them in the chat, and we'll address them in the questions session towards the end. yeah, otherwise I think we'll be addressing some questions that have already been put forward. Thank you, Donna, over to you.
Hi, everyone, and thank you, Sarah, for the introduction and for inviting me to talk today. As she mentioned, I'm a solicitor and a community with welfare rights. I'd also like to acknowledge that I am currently on the Gadigal land of the Eora Nation, that I am working remotely from their land, that their land was never ceded, and that it always was and always will be their Gadigal land. So as I was saying, we're a community legal centre that specialises in social security law, which means that anyone who has issues with their payments from Centrelink can come to us, that we can assist them, give them advice. We offer both one-off advice, just talking to you about your problem and what might be going on and giving you some advice about what your rights are. But we also do representation, and that representation can be to Centrelink or it can be to the Administrative Appeals Tribunal. We also do community education sessions like today. We run a whole program of community education sessions ourselves. And we also, in partnership with our peak body, we do some policy work as well, where we advocate to Services Australia and to the government for changes in the law as it currently stands in trying to improve people's rights to a payment from Centrelink. So what we do, we assist about 1,700 people a year currently. One of the things that's really important to understand is that a Centrelink decision is what we need in order to be able to help people. So we need Centrelink to have actually made a decision before we can advise and assist, or alternately, you can also, if you're in dire financial circumstances, you have no source of income, please come to us. It doesn't matter whether you think that you might be in a position where we can help or not, just come to us. Talk to us and let us tell you if we can represent you or not. One of the things that's important for you guys, or that's good for you guys to know, is that we do have priority clients and they're more likely to get actual ongoing advice and assistance from us rather than one-off advice. And people with caring or family responsibilities are one of those priority clients. So a lot of all the information that I'm giving you today is information. It's not legal advice. I'm not advising you on what you should do. I'm giving you information about your rights. Please come to us to get actual advice about your individual circumstances. So what I'm hoping for you guys to get out of today's session is I would like you to have more information about who's eligible for care payment and care allowance, what you need to get onto disability support pension yourself or to assist the people that you are caring for to get onto the disability support pension, what you may be able to do if you get a debt, how you question a Centrelink decision, and also some tips for dealing with Centrelink. So just to give you a bit of an idea, it is a very, very, very big system. There are a massive number of people in Australia that have a relationship with Centrelink. There are millions of people in Australia with a relationship with Centrelink, and there are hundreds of thousands who are on care allowance or care payment. When you're talking about a system that big, you need to understand that mistakes happen. That when the mistakes happen to you, that when something happens that affects you, it feels personal, but it is an enormous system and these things do happen. Okay. So what I'm going to start with is about who is eligible for a payment from Centrelink. There are certain things that everyone needs to have covered or to be aware of when they're applying for a payment. These are things that affect every single payment that Centrelink administers and gives, and not just those affecting people who are carers. So you need to be a permanent resident or an Australian citizen. So that means to be on a particular permanent resident visa or to be an Australian citizen. You need to have actually been physically inside Australia when you lodge your application, and you need to be intending to remain here for 2 years. Look, that can change. You can decide within the 2 years that you're leaving, and that won't affect your eligibility back into the past. But at the time that you apply, you need to be intending to stay. You also need to call Australia home. So it's not that it is your right to be here or that you're a citizen. You actually need to be living here as your home and not just visiting and on your way passing through. Then the other practical bits and pieces you need to have when you're making the application. You need to have ID. You need to prove you are who you are. You're going to need to show them how you've been financially supporting yourself. And you and the person that you're caring for are going to have to go through an income and asset test. And those income and asset tests are different for every payment. So what Centrelink wants to know about and how Centrelink assess your income and assets changes depending on what payment that you're looking at. I really wanted to tell you briefly about this particular aspect of qualifying for a payment from Centrelink, because changes that the federal government are wanting to bring in over the next 6 months affect carers more than anyone else. If you've newly arrived in Australia, if you're on a permanent residency visa and you've only just and you've received that visa only recently, then you have to wait in Australia on that permanent visa for a period of time before you're eligible for a payment. As you can see from this slide, that for most payments, it's 4 years that you need to be supporting yourself in Australia without any assistance from Centrelink. Some payments, and they are mostly payments that recognise people caring for other people, are a shorter waiting period, that those people need to not be penalised to wait that long. But all of those payments, the carer payment, the carer allowance, and those payments for people for parental caring purposes are all going to be increasing to 4 years if the federal government passes legislation in the next few months as they intend. And those new waiting periods will be starting from the 1st of January. Oh, by the way, with that, if you disagree with that, contact your federal MP. Yeah, and let them know that you disagree. And let them know that you don't want them to write and pass that legislation. So, carer payment. We're going to talk specifically about carer payment now. In order to be eligible for the carer payment, it's an income support payment, which means it is meant to be enough income for you to support yourself and not just supplement income from other sources. To be eligible for the carer payment, you need to be providing full-time daily care that's described as constant care to either a frail age person or a person who's a child or adult with a disability or a medical condition. Now, that full-time daily constant care means that as a result of providing that care, you're unable to work full-time out of the house. And it means that it's for 6 or 7 days a week. It is not full-time 5 days a week, the equivalent of full-time work. It is 7 days, 6 or 7 days. In some circumstances, it can be 6, but 6 or 7 days. You need to be providing the care in the home of the person that needs the care. So it is not care provided in your own home or in someone else's home or anywhere else. It's not care provided, while they're in hospital or anything else. It is only care in the home of the person needing care. And the care needs to be needed permanently or for a minimum of 6 months, or if they have a terminal illness. So someone who needs care can have more than one caregiver. So more than one person may be eligible to receive carer payment as long as both of those people are providing that constant 7-day care. Okay? And it needs to be for enough time throughout the week, 25 hours or more a week, that you are spending giving that care every single day. And both of you need to meet all of those eligibility criteria. Okay. You can have a single carer can be caring for more than one person, but it is exactly the same. You need to be meeting those care requirements for each of those people, but you only get the one payment. You're not going to get carer payment twice just because you're caring for more than one person. And the disabilities that that the people you're caring for need to be assessed under particular disability care assessment tools, which is the adult disability assessment tool for adults or the disability care load assessment for children. If the person you're caring for has a terminal illness, then it's not the 6-month requirement, it's a 3-month requirement that if you're likely to be caring for less than 3 months, then you are still eligible for carer payment. Okay. So with the carer allowance, it's not an income support payment. Okay. So this is a payment that is only supplementary to any other payment that you may possibly receive. You need to be providing care and attention on a daily basis. Daily basis is strictly 7 days. Okay. With the carer payment, it's 6 or 7. With the carer allowance, it's strictly 7 days. But the care can be given in your own home as well as the person's home that is needing the care. It doesn't have to just be in the care receiver's home. It's got the same assessment tools, but the care needs to be needed permanently or for a minimum of 12 months rather than the 6 months of the carer payment. Both the caregiver and the care receiver need to be Australian residents. The care needs to be provided by a parent or guardian or a family member of an approved person, and the income and asset test apply to both the carer and the care receiver. So some of the top tips for carer payment and care allowance that it's good to keep in mind if you're having problems or if you're a carer who's receiving the payments is that there is a respite care available that's up to 63 days a year, and you retain your eligibility for the payments even if the people you're caring for are not in your care during those 63 days. But you don't get 63 days for payment and 63 days for allowance. It's not 126 days in total, it's 63 only. Remember that care provided in your own home is not considered for carer payment. It's only care provided in the care receiver's home. And one of the really good things, one of the good top tips that you have is if you're trying to get onto a carer payment or allowance and Centrelink is questioning the care that you provide and how much care you provide, start keeping a diary and record in your diary, you know, when you go to the house, what you do when you're there, the time you arrive and you leave, and exactly what you're doing, whether it's cooking, cleaning, helping with medications, obviously helping with hygiene and everything. Record everything that you do. And remember that just supervising someone counts towards the provision of care. You don't need to be actively doing something if you're monitoring and you're supervising. That counts towards the provision of care for social security purposes. Okay. So you or the people you're caring for may also be attempting to get onto the disability support pension. So I wanted to just quickly mention some of the things about eligibility for the DSP. DSP is one of the more complicated payments to get onto. It's one of the harder ones to work through the process and provide the eligibility, provide the evidence for. We run full sessions dedicated to disability support pension alone that run for well over an hour, 2 hours long. Okay, so it is quite complicated. So what I'm talking about now is very brief and very general. We have a fact sheet that you're able to go to read more specifically about the DSP, and we actually run a DSP clinic to assist people who are struggling to get onto it. So the things to be aware that each of you need to have a physical, intellectual or psychiatric condition that affects your day-to-day life. Okay, so just having a condition isn't enough. Your day-to-day life needs to be affected by the condition. The condition needs to be fully diagnosed by an appropriate medical professional. You need to have undergone every treatment that's possible to undergo that may improve your condition, and you need to be fully stabilised and unlikely to change over the next 2 years. And then, if you say yes to all of those things, your day-to-day life needs to be affected to a degree that you are awarded 20 points on the impairment tables. There are ways that you can be found manifest eligible, you know, if you have a terminal illness, if you're permanently blind, okay? And so there are always exceptions to everything. Even if you say yes to all of those things, if Centrelink think that you are able to work 15 hours a week or more, then you will be considered to not be eligible for the disability support pension. So you need to also not be able to work 15 hours. You need to, your ability needs to be less than that. You become eligible for the DSP when you turn 16, and you lose your eligibility once you reach age pension age. Okay? One of the other things you need to be aware of, especially for people moving between countries, is where you were living in the world when you became unable to work can also affect your eligibility. Okay? So there's a whole load of different complexities as a part of it. If you lodge an application and you're rejected, please come to us. Let us talk to you about it and let us figure out what's happening. With the impairment tables, there's 15 different impairment tables. So when you're looking at whether you're going to get 20 points or not, there's a whole load of different impairment tables that they look at. A single disability, you might get points under more than one table, okay? But you can only get points on a table once. You're either going to get 0, 5, 10, 20 or 30 points. And you can add those points together in order to make up your 20 points. Okay? So the impairment tables that there are, these are the 15 ones. I'm not going to go through them. We can send you copies of those tables if you need them. If you're looking at getting onto the disability support pension, the medical evidence that you get is critical. It really is important that it addresses all of the different aspects of assessing your eligibility for DSP. So diagnosed, treated, stabilised, how your day-to-day life is affected. As I said, there's a fact sheet available, and our peak body, Economic Justice Australia, has it on their website, or it's also on our website. We have template letters that you might be able to give to your doctors to fill in, which will ensure that the doctors are covering everything that Centrelink needs, and we can send those to you, as well as copies of the impairment tables. And Social Security Rights Victoria have a website that you can go through the steps, and it will produce letters about your medical evidence and what you need. So it's worth exploring all of those. So top tips, and all of these, as I said, it's an incredibly complicated area, but just be aware that every time you ask, or the person you're caring for asks for a medical exemption from an employment services provider, that may affect their eligibility for the DSP. So read the fact sheet first. Okay? Another thing you should be aware of is that you have the right to change your employment services provider. You don't have to accept the one that you've been given. There are disability employment services providers that will adjust your mutual obligations to your abilities, and will hopefully support you in ways that support your abilities and your medical conditions, rather than just giving you a one-size-fits-all. So have a look around your area, see what employment services providers are there, and choose one that you think fits with what you need. Okay. So last bits and pieces for the payments that you might be receiving, or the payments that you might want to use. Okay. So mutual obligations. A lot of you may be on a job seeker payment and be needing to undertake mutual obligations in order to remain eligible for that income support payment. it's really helpful to know that caring responsibilities should be taken into consideration when they're designing your job plan and your mutual obligations. Okay. If you lodge an application for the DSP, or if the person that you're caring for lodges an application for the DSP, while that application is being considered, your mutual obligations should be suspended. Now, once a decision's been made and you're going through an appeals process, then the mutual obligations will come back. It's only while that initial decision's being made that there's the suspension. Okay. And you can also ask to have your mutual obligations temporarily suspended. Okay. And those temporary suspensions of mutual obligations might come into play if you are caring for a dependent child with a disability, when a dependent child has an illness or injury that suddenly means they need full-time care. The caring for a frail or age disabled family member, where a person's carer isn't available anymore and that person is the one with the mutual obligations. Okay. If the person you're caring for has mutual obligations and you are not able to care for them for a period of time, then they may be able to get an exemption from the mutual obligations. But actually, they will look at your case as it happens and go through it and look at it a case-by-case basis and make decisions in that way. So the key things to remember are that the carer payment's an income support payment. It replaces income. So you can't work while you're on the carer payment. If you work for 25 hours or more, then you'll lose your eligibility for the carer payment. Okay. But the main issue with getting onto the carer payment is that constant care. So if you are caring for less than 7 days a week, or sometimes 6 in some circumstances, you will not be eligible for the carer payment. Okay? If you're only caring 5 days a week, then you will not be eligible for the carer payment, and there are no exceptions to that. The carer allowance is an additional support payment. Okay? It's not enough money to live on. Okay? You can work when receiving the carer allowance. The income and asset tests are more generous. Okay? The disability support pension is incredibly strict and incredibly complicated, and the rules about evidence are very convoluted. And if you are rejected, appeal the decision, come to us and let us talk to you about it, because often it is just what's in the evidence that's the problem rather than what's going on and what the disability is. Okay. A lot of people get tripped up by the fact that the condition needs to be permanent with no treatment options available that will improve it. So make sure that you get advice on what that covers and what that's likely to be, because that just might be what's going on. So the final part before we move on to appeals and what you can do about a problem with Centrelink is that I wanted to talk about is debts. Everyone who receives a payment from Centrelink may get a debt at some stage. Okay. You get a debt in all sorts of circumstances. You don't have to have done anything wrong. You don't have to have attempted to defraud or done anything malicious or deliberate in order to get a debt. Debts happen. They can be as a result of a mistake from Centrelink. They can be a result of an inadvertent mistake from the person getting the payment. Okay. If you get a debt, this is what it's going to look like. These debt notices can be are quite confronting. They can be incredibly difficult to read, and it can be incredibly hard to understand exactly why a debt has happened and why a debt exists. So if you have a look at this particular slide, up the top in the black box, that's the amount of money that is owed. Okay? And underneath it, you'll find that there is a due date by which you have to pay. Now, the payment, you don't have to pay the entire amount by that time. You just need to get into a repayment plan by that time. And getting into a repayment plan is not going to affect your ability or your eligibility for to appeal it. You're not saying, yes, I owe this money by entering a repayment plan. You're just, starting to repay it. Okay. So the second circle on the left-hand side, that's where it tells you about why the debt's come about. And as you can see, it doesn't give you a huge amount of information. So for this particular one, it says the correct value of your assets is different to the amount we used. It doesn't tell you what assets they're talking about. It doesn't tell you what the value of the assets are. It doesn't tell you how they came up with that amount or anything about it. It just says, that's all it says. Okay. And then underneath it, it says what period of time you were overpaid and that you were getting payments that were more than you were eligible for. Okay. On the right-hand side is the telephone number that you need to call in order to make those repayment arrangements. So having a look at this, you can see that although there's some information on there that can be found when digging a little bit deeper, it doesn't actually tell you a huge amount about why decisions were made. Okay. And the other really big thing that it doesn't tell you that is incredibly important to know for if you do get a debt is that if you question the debt and if you ask Centrelink to have a look and see if they made the right decision, and if you appeal the debt, then Centrelink, when looking at that debt, may decide that actually instead of a $5,400 debt, you should have received a $10,000 debt, and your debt can go up. So questioning Centrelink with debts can be incredibly risky. And it's really, really important to get advice before you question whether a debt should have been raised or not, because you don't want to go to them with a $300 debt that turns into a $3,000 one. You can't ask them to go back to the old debt, unfortunately. So I wanted to quickly mention some of the common reasons why a debt might actually come about. Okay? It could be that the person didn't report their income correctly. It could be that they reported for their carer payment or their disability support pension or one of those payments, but they didn't report for family tax benefit or a different payment that they were receiving at the same time. And you actually often need to report twice. You need to report for every payment that you get, and a single reporting isn't necessarily going to be given to all of the departments that will manage your payments. Family tax benefit doesn't talk to carer payment department. Okay, and if you're receiving both, you need to report for both. Okay, it might be that you were receiving a payment that you actually weren't eligible for but never realised. Okay, it might be that you are being paid as a single person when you're actually in a relationship, and the way Centrelink looks at relationships can be incredibly complicated. But also, Centrelink might have made a mistake. They could have got it wrong. As I was saying before, it's an incredibly large behemoth of an organisation, and they can make mistakes. Okay. You can appeal a decision to raise a debt, and there's all sorts of different ways that you might ask them to look at that debt and make a new decision. You might be saying that they got it wrong, that they got their facts wrong, that asset reassessment was incorrect, and that actually should never be a debt. Okay, it might be that you believe they got the maths wrong, that they just did the calculations incorrectly, and so therefore the debt is just the wrong amount. It might be that you think Centrelink made a mistake and that you did absolutely nothing to contribute to that mistake and to cause that mistake to happen. It might be that circumstances in your life, whether they're health, financial, caring, all sorts of different things, might be such that you believe you shouldn't have to repay the debt, even though you got more money than you're entitled to. You think that you shouldn't have to repay it. or it might be that you're asking them to write it off until you're able to repay it at a later date. Okay. But it's incredibly important, and I will probably say this a couple more times, don't appeal a debt without getting advice first. Okay. Please get advice from us or someone else first before you lodge an appeal, because as I said, you don't want your debt to go up. You don't want them to question whether they paid you the right amount and put it up. Sometimes you have to do a freedom of information request to truly understand whether there's a risk of your debt going up. And this is one freedom of information request we got. They're big, they can be big, they can be complicated. You don't know what Centrelink knows. You don't know why they made a decision until you look, and you just need, sometimes you need to look in your Centrelink file before you know, okay? So yeah, it's just that debt notice alone is often not enough to be able to tell why a decision was made and what your chances of success are if you appeal a debt. As I said earlier, you need to get into a repayment plan before your the due date. If you don't, you will be charged interest, and that interest can be substantial. And if it does get sent, if you don't get into a repayment plan and it's sent to a debt collector, it's a 10% debt recovery fee that is put on top of your debt. Okay. The standard repayment is 15%, but you don't have to repay that. You can talk to them and you can negotiate a lower amount. Okay. If you don't, they can access your bank accounts. They can garnish your wages. Okay. As I said, get advice before appealing a debt. Okay, so you have the right to appeal a decision from Centrelink. If we can move to the next one. Any decision that Centrelink makes can be appealed, but not every decision should be appealed, okay? And it's important to get advice to find out whether you should be appealing a decision. Okay. The sorts of common decisions that are appealed and can be appealed and that you might come across is if an application for a payment was rejected, if your payment rate is reduced, if you're suddenly receiving less money a fortnight, if your payment's suspended, if it's cancelled, if you get a debt, if they reassess assets, if they assess your work capacity and you disagree with it and you don't believe that you are capable of working the number of hours that they've decided that you are working, if they refuse to accept a medical certificate that you've submitted to be exempt from mutual obligations, these are all decisions that can be appealed, and it's a very simple process to actually appeal. It's not onerous, it's not hard, it doesn't have to be a really big difficult thing in order to appeal. You may have to, you do have to ring Centrelink, and I know that sometimes you can sit on hold for a little while, but it is just simply a request. You're just calling or walking into a Centrelink office and saying, I would like to appeal this decision. Okay. You can ask for either an explanation of why a decision was made, or you can ask for it to be formally appealed to an authorised review officer. Now, the authorised review officer is an independent person in Centrelink who had nothing to do with that original decision. Okay, so it's a brand new person looking at your application or what happened with new eyes and seeing if it was the correct decision to make. Now you have to go through that authorised review officer's decision appeal before you can go any higher. Okay, but if you have done an authorised review officer's appeal and you are not successful, it doesn't have to be the end. You can then move on to the external review at the Administrative Appeals Tribunal. Now, the Administrative Appeals Tribunal is set up for people to represent themselves and for them to support people to represent themselves. It doesn't have all the trappings and formalities of a formal court. And so they're really happy to help anyone that comes along with their appeal. To appeal to the Administrative Appeals Tribunal, it is just a phone call. You ring them up. You ring the 1-800 number on the website and you say, I would like to appeal a decision that Centrelink made. And they will lodge the appeal. It's very simple. It's very straightforward. The member, it's during the appeal, it's just you and the member, and that's conversation. Okay, there's no formal trappings of the normal court system. If you're not successful at the first level of the Administrative Appeals Tribunal, you can go to the next level. But the next level is the General Division of the Tribunal. That is more formal. It is a more formal hearing. Centrelink will send a lawyer to represent them. It's just far more like a normal court hearing at that process, that point. It's also a more formal process to lodge your appeal in that it needs to be in writing, unlike the first level. But just remember, appealing a decision can be a very informal, easy process. It's a telephone call. It doesn't have to be difficult. You don't need to be writing formal appeals in order to do it. It can be quick and easy. And it's your right to question decisions of Centrelink. It is your right to ask them to look at it again and see if it was the correct decision to make, and to ask the Administrative Appeals Tribunal the same thing. If you're lodging an appeal, it's very important to remember that there are time limits. And if you don't lodge your appeal within the time limits, then even if you might have won, you probably won't get the money you would have gotten otherwise. Okay, so if you don't lodge in time for a rejected application or a reduced payment or a cancelled payment, you're not going to get back paid to the day that that application was lodged or your pay was reduced. Okay, you're only going to be back paid to the day that you lodged your appeal, which can be months and months of pay that you're missing out on. Okay, and if you don't lodge in time for some of these levels, they won't accept your appeal at all. Okay, so they're just going to go, they will just say, I'm sorry, you've lost the right to appeal and you cannot appeal at this point. Okay. Most payments, it's 13 weeks, or most decisions, it's 13 weeks from the original decision to that internal review by the authorised review officer, and then 13 weeks from Centrelink to the tribunal. But some decisions, it's only 28 days. Okay. And if you're going from the first level of the tribunal to the general division, it's only 28 days, and it is very, very hard to get them to extend that. Okay. But, and I'm going to say this about debts again, you're going to be sick of this, but you're never going to forget it. There's no time limit to appeal a debt, and you should not appeal a debt without getting advice first, because you don't want the debt to go up. So if you owe Centrelink money, then there is no time limit to question whether that was the right decision. Okay. You can appeal a debt years after the debt was raised, if that's what you would like to do. So with decisions by Centrelink and with things with regards to Centrelink, you do have options beyond and outside of that formal appeals process. Okay. You have the right to contact a Centrelink social worker and to have a Centrelink social worker assist you. There's not as many as there used to be. Okay, you just need to ring Centrelink and say that you would like an appointment with a Centrelink social worker. They can be incredibly helpful as an intermediary between you and Centrelink. They can be incredibly helpful with helping you with your evidence and other situations. Just remember that they're there and you can use them. Okay. If you have questions about finance decisions, it may be that you've got some complicated assets or trusts or business, or if you own your own business and you're doing things from home, or all sorts of other things that are going on, you have the right, you can call the Financial Information Service. They are a part of Centrelink. So what you tell them, you're telling Centrelink. So be aware of that. It's all part of Centrelink, but they're there to help to give information about complex financial issues. Okay. You can make an appointment to talk to them, or you can just ring and you might be able to talk to them straight away and just off the cuff. Okay. The telephone number's there, but remember that they exist and that's the service that you can use. And then finally, if you're upset and you have an issue with the way that you have been treated by Centrelink or by your employment services provider, then you have the right to make a complaint. So there's a Centrelink complaints and feedback line that you can write to or that you can call. They're meant to be contacting you back once they've assessed your complaint. If you've got a problem with your employment services provider, it's not a Centrelink issue. You can't go through Centrelink. It's the Department of Employment and you can lodge a complaint there. Okay. If your employment services provider makes a decision that you disagree with, you cannot, it's not a Centrelink appeal. Okay. It is it has to go through the Department of Employment. And then you can also complain to the Commonwealth Ombudsman. So the Ombudsman can't compel Centrelink to act. They're not going to give you legal advice or assistance. They refer people to us when that's the case, but they will investigate complaints and they can look at the service that you've been provided with regards to Centrelink and investigate that and deal with that. Okay. So if you want to contact us, we're open for advice on Mondays, Wednesdays and Thursdays. That's the telephone number there and the times there, and you can call us and we'll be really happy to make you an appointment to talk to one of our solicitors. Our contact details are here. Now, if you're on the South Coast, the Illawarra Legal Centre in Turton is a social security solicitor that assists clients along the South Coast. So you can give them a call. For the rest of New South Wales, it's us. And they're the way that you can contact us for advice and assistance. And if you are a service rather than a carer and you would like training or workshops, then that's my contact details there. Okay. And then finally, a lot of updates we give over social media as they come. So the latest news about mutual obligations and COVID and how people will no longer be suspended if they are not complying with their mutual obligations as a consequence of COVID. We announced on social media. So all of those sorts of changes are announced on social media as they happen, and you can always follow us to keep up to date. Thank you.
Thanks so much, Donna, for an excellent presentation and for your perseverance despite the many tech challenges. We have had 2 questions come through. I don't know, Donna, whether you want to respond quickly to either of those.
I'm really happy to. Yep.
One was, what do you do if your GP does not want to help you apply for care allowance, e.g. if they don't recognise emotional support?
You'll have to find in order to get onto care allowance and care payment, they assess evidence from a medical professional. You cannot get on to either payment without evidence from a medical professional, so you need to find a new doctor.
Great. Good brief answer. Thanks for that. Another one we had here was in relation to COVID. What happens when one is unable to do the 7 days of care due to risk? Can the 63 days be extended? This happened last year and
No.
pension was cut.
There are no extensions to those 63 days, unfortunately. That's all there is. You lose your eligibility for the payment if you go beyond those 63 days. My understanding is that there hasn't been any changes to that have been brought in for COVID. If I find that something is different, I'll let Carers New South Wales know and they'll pass it on.
Great, thanks very much for that. And we don't want to hold everybody too long, but I guess one thing that did come up for me hearing the presentation, Donna, there are a number of aspects of this system that are challenging and some that may seem unfair and may be unfair. And as Donna said, Welfare Rights Centre definitely, argues for changes where they're needed, as does Carers New South Wales. So if you are experiencing issues and you want to raise those to highlight anything that you think should change in terms of policy, our policy team is happy to chat to you and make sure that we include that information in our ongoing advocacy. So some of these rules, there's possibility for us to argue for changes to be made if they make things difficult for carers. But hopefully you've learned a lot today. I certainly have. If there's any additional questions, please do contact us or Donna using the information provided. Grace will send out an email with some key information in it after this, and we will share the recording and the slides with you. We will amend the recording so we cut out the tech problems part. And the other thing just to mention is that we have other sessions coming up next month and the month after. So we'll send you the link to the website so that you can register for those if you're interested. We will also send you the fact sheet that relates to this webinar. And feel free to contact us with any further questions. And I guess the closing point really is we really want to encourage carers to seek support if they've got questions or challenges around income support. As you can see, Donna and her colleagues at the Welfare Rights Centre know the ins and outs of this like nobody else, and they're very willing and available to help. So please do use that. You don't necessarily just have to put up with something that you think is correct or unfair, and that is the point of this series, is to help carers understand how they can follow things up. So I think we might end there. Thank you everybody for joining. Thanks again.